Good morning, everyone. Hello, my name's Greg Falkov. I'm a partner in the International Arbitration team at Evershed Sutherland. Thank you also from me for joining us today. The title of today's session is Dealing with Fraud and Corruption in International Arbitration. Now, that is a very broad topic. That is enough to have a number of full-day conferences on, so we've narrowed the topic slightly. We'll be looking at dealing with corruption only. We're not addressing the issue of fraud. Now, corruption is a topic that I wished we didn't need to address. I prefer that it didn't intrude into our world of international arbitration, but unfortunately it does. And it does not because of any intrinsic characteristic of international arbitration, but rather because corruption is endemic and it's widespread. The annual Corruption Perception Index from Transparency International ranks jurisdictions on the basis of perceived corruption at all levels of a nation's government and economy. The most recent report makes for quite sobering reading. 22 countries have significantly lower scores than previously, and that suggests an increase in corruption and an increase in corruption being perceived by residents of those 22 countries, which obviously is not a good thing for anyone. Over 90 countries have registered stagnant corruption scores for over a decade. Now that suggests across half the world, government efforts to root out corruption and the causes of corruption have stalled, have reduced. And the worst statistic in my view is that out of a maximum score of 100, more than 2/3 of jurisdictions across the world score well below 50. And in such an environment, it's inevitable that allegations of corruption do make their way into international arbitration, and this may be more common than we think. Could I briefly get a show of hands? During your own practice, during your own career, have you ever come across an allegation of corruption at some point? If I could ask for a show of hands. For those who are dialing in online, that's almost the entire audience. Now, could I ask, for those of you who've come across corruption allegations within the past 3 years, could you raise your hands? Thank you. And also for those on the dialing in online, that's probably half the audience or more. So corruption is common. It is endemic across international arbitration, unfortunately. And today what we're going to be looking at is we're looking at the life cycle of an international arbitration procedure. We'll explore the issues that come up during an arbitration dispute when these allegations of corruption are raised. And we're going to look at this chronologically. So we'll start with the decision to allege corruption. Then we'll explore how this plays out into the arbitral process. And then we'll explore the deliberations, and then finally we'll discuss corruption in the award and also in post-award activities. And with me today, on your left, firstly is Gaurav Sharma. Gaurav is from Quadrant Chambers. Gaurav specializes in energy disputes, and in a former life, Gaurav was senior litigation counsel at one of the world's largest oil companies. Gaurav will bring the client's and the organizational perspective to our discussion. Second, we have Claire Stockford, my partner at Eversheds in London. Claire has an interesting view of these issues. She has substantial experience of acting as counsel in disputes involving some of those more difficult jurisdictions, the jurisdictions that score very low on the Corruption Perception Index, those 22 countries where corruption got worse over the year. And this is the perspective that Claire brings to our discussion. And last but not least, we have Angeline Welsh from Essex Court Chambers. Angeline acts both as counsel and as arbitrator, and she's grappled with these tricky issues of determining allegations of corruption and of assessing evidence put forward in support or in defense of corruption claims, and considering how tribunals address these issues. And Angeline will provide the tribunal's perspective to our discussion. So let's start with the first-in-time section. This is the initial decision to raise corruption arguments before corruption is pleaded, whenever that may arise in an arbitration. This is usually, but not first, always considered by a respondent in defense to a claim. Sometimes the claimant may not know of the corruption defense. Other times it may be expected. It may even be foreshadowed. How do clients deal with these? Are there any relationship issues? How do counsel deal with these? These are some of the questions. Gaurav, can we start with you to kick off? Let's start with the client perspective. What thoughts go through a company's mind before it makes a decision or before it decides to allege allegations of corruption or dishonesty in arbitration?
Well, good morning, Greg. Good morning, everybody. Nice to be here with you all today. I think there are probably two major considerations that companies will go through, that clients will have to think about. On the one hand, you've got the legal perspective and the legal analysis that needs to be done when you're formulating the claims. And on the other hand, you've got the commercial issues that need to be addressed and considered and fully thought through as to whether you're going to make the sorts of factual allegations about corruption and dishonesty, and it could even be fraud, and other sorts of dishonesty claims as well, before you go ahead with those. And I think when you look at it from a legal perspective, many of the things, the considerations when it comes to these sorts of allegations are probably not dissimilar to the sorts of analysis or analyses that you would find in any other arbitration claim or defense, namely, do you have the elements of the cause of action or the defense? What are the prospects of that succeeding? What does the evidence look like? What is the cost? What's the timeline, etc.? I don't think any of those things are necessarily massively different. I think in my experience, which is both as external counsel and internal counsel, I think where the big difference lies is in whether you are going to make these claims from a commercial perspective, because typically these are the most serious sorts of allegations that you can make about your counterparty, that they have acted dishonestly. And these are deeply personal claims that you're likely to be making about the person on the other side of the table that you've been dealing with for years and years, and you may still be dealing with for many years after the arbitration is complete. And on that point, I think the big thing to bear in mind is that you are not really likely to be pointing a finger at a company and saying that the company has acted dishonestly, that it has acted with dishonest intent. That is likely, I think, in my experience, to fall flat when you present that to a court or a tribunal. What you have to do is show evidence of particular individuals acting dishonestly within the organization. You have to pinpoint who they are, what exactly it is that they're said to have done, how and when, and you've got to provide all of the supporting evidence. So it becomes a deeply personal sort of allegation to make, whether it's in defense or as part of a claim. And when you're making that sort of allegation, it probably goes to the very top of the management as well, because it may be that the allegations concern specifically junior members of the employment, of the people who are working on the other side of the table. But there's a good chance that you'll be suggesting that the senior management have turned a blind eye to the conduct, or maybe are implicated in it themselves directly. So it's a very serious allegation to make, and it's bound to have an effect on the commercial relationship that you have. So I think, to cut a long story short, that's probably the biggest differentiating factor that I've experienced in my career, certainly internally, working within companies, considering these sorts of allegations. And it really affects the question of whether it's commercially viable to bring the claim or not, or the defense at all. I think different considerations apply when you're talking about maybe public officials and criminal issues that come into play as well. But when it's a civil offense of bribery or corruption, it's a tough call to make when you may have 10, 15 years left on a contract, maybe a suite of contracts with the counterparty, and you're considering alleging dishonesty on the part of the people that you deal with every day.
Thank you. And taking that one step further, also from the internal perspective, from the client side, does the existence of corruption allegations impact on the way in which a company deals with its messaging to its shareholders, its public relations regarding the dispute or the allegations?
Yeah, I think it does, predominantly because corruption stories, I think corruption allegations are rarely good news stories. And I'm not suggesting that that breach of contract claims or other civil claims are good news stories in any particular way. They typically are not. But at least they have a more commercial aspect to them. They typically involve deadlocks, commercial legal deadlocks that have taken place between the parties or happened, that can be explained to shareholders, to stakeholders in a sort of logical way, a difference of an interpretation of an agreement, for example, or some other commercial issue that's arisen, force majeure, whatever it happens to be. When it comes to corruption allegations, that might not be the case. Your center of gravity in the case is the dishonest behavior. And it's quite hard, I think, in my experience, it's quite hard to disassociate yourself, whether you're the claimant or the respondent, from the tainted allegations that are being made. And the chances are that, especially today, you're going to leave a digital footprint. You know, if your claim makes its way into the media through whatever means, your company is going to be associated with those claims for some time. So I think a sensible organization would take every step to be prepared when it's making these claims or defenses, to get ahead of the game and to make sure that you have a narrative that you have pinpointed exactly what your allegation is, who it's directed at, and what your company's role in this process was or was not, so that you're ahead of the narrative and you're controlling any reputational damage or share value loss and impact that these sorts of claims typically and often do have.
Claire, could we pick this up from the counsel perspective, perhaps? At this early stage, before the corruption argument has been run, you'd be advising your clients on the potential legal effects of raising a corruption argument. What do you consider? What possible remedies might be available? What are the options for the client?
Thanks, Greg, and good morning, everyone. At the beginning of his first response, Gaurav mentioned some of the points that both internal and external counsel can consider in every claim, legal arguments, evidential issues, and so on. When you are considering raising an issue of corruption, an additional point to consider is arbitrability. Under English law, you are generally fine because of the doctrine of severability. So even if you are looking at a contract that is tainted by corruption and is potentially voidable, you can usually still bring the arbitration. That might not be the case under every system of law, and obviously in arbitration we are dealing with many different systems of law, so that's an important point to check early on. If you are in the investor state side of things, you need to look at what the applicable treaty is saying about this. Some treaties, more modern treaties, are tending to bring in a requirement of lawfulness for the investment. So if you are talking about an investment that is tainted by corruption, you might find you are not actually able to bring the arbitration. And even if you can, there are instances of tribunals, even where it's not explicit in the treaty, finding that a qualifying investment needs to be one that isn't procured by corruption. So I think that arbitrability point is an extra point that comes in when you are looking at a contract that might be tainted by some form of corruption.
And to follow up on that, let's look at planning and strategy for running that corruption dispute. Before you make the argument, what are the strategy and the planning issues to consider? What are the traps? What are the dead ends that you could run into if you run a corruption argument later on down the line?
I think one of the real traps to consider is how it might play back on your client. Particularly if you are going up against a state entity, but in any case, you could have the corruption argument played back at your client, or there could be some other retaliation. I have been involved in cases where corruption arguments have been made, and then my client has found itself subject to tax investigations, labour law investigations, regulatory investigations, and even if wholly unfounded, they can be costly both in terms of time, money, management effort, and so on in dealing with those. And of course, your opponent will make hay with them while they are extant, even if they are eventually dismissed. And in one extreme case, I've actually had my clients subjected to Interpol red notices, which obviously had a huge impact on their life and in their involvement in the arbitration, and until we were able to get those lifted. So it's just sort of thinking about the tactics that your opponent might employ at the most extreme to retaliate against you and your client. And the other sort of key point to consider, of course, is whether your client can actually make out the allegation of corruption, because evidencing these things is often very difficult. And sometimes it is worse to make the allegation and have it fail than not to make it at all. I was involved in a case many, many years ago where someone on my client side actually knew the amount of the bribe in terms of Adidas. And I didn't know this was a unit of currency among certain circles. It's apparently how many US dollars you can fit in an Adidas sports bag. So we knew the amount, we knew who it had been paid to. We could not prove it. We did not make the allegation in the arbitration. So evidencing these allegations can be really, really difficult because of the nature of them.
And on that point of the knowing the allegation, knowing the amount, who it was paid to, but not being able to run it in the arbitration, did that result in an unsuccessful outcome for the client who would have liked to bring a corruption plea but was unable to?
The client was actually successful on other arguments, thankfully.
So that's some of the issues, at least, before you bring the corruption plea. Then we move on to the second of our sections, let's call it, which is corruption arguments being raised and pleaded during the life of the arbitration process. How might corruption play out in the arbitration? What are these issues to consider for counsel and also issues for the tribunal? Before we turn to Angeline on this, Gaurav, could I go back to you for a moment? Let's start with some of the issues of evidence in relation to a corruption argument. As counsel, is there anything different that you'd need to do when it comes to the task of assembling evidence when you're looking at potential corruption arguments?
Well, Claire's touched on some of them, and I think that's the key message, the one that Claire's just delivered, as far as I'm concerned anyway, which is that as counsel, you really have to put your name behind the claim that you're about to make or that your client is about to make when it comes to fraud. You have to anyway, but of course when it comes to fraud claims or dishonesty or corruption claims, there's a particularly important aspect to this where counsel typically is expected by international tribunals and certainly courts all over the world not to bring these sorts of grave and serious claims unless counsel has assessed the evidence carefully and is convinced and persuaded that the evidence exists to support the allegations. And that's very different, I think, from a speculative, if you like, legal claim that's brought for a breach of contract or whatever it happens to be, where you understand that the chances or the prospects of success are moderate, potentially. They could be 50-50, they could be 60-40, they could be 20-80, but you can run the argument and you can do it with a lot of force. That's not the case, I think, when you're making corruption and dishonesty allegations, where you're expected to have looked at all of the evidence before you put your name to it and presented it to the tribunal for consideration. Seen that recently in the English courts here. I think a few months ago we had the King and Stiefel case in the High Court. Again, just reiterating the point that there has to be material to support the claim. And I think the way that you do that, if you're counsel, is that you have to take a deeply objective approach to the evidence that you have. You have to recognize where the gaps are as well. You have to look at the evidence and decide whether it supports the inference that you are going to invite a tribunal to draw based on what you have. So, I mean, to give an example, if you were to take a sort of classic example of a procurement of a contract, and the qualifications of the party that's obtained the contract to actually perform it, if those credentials are found to be lacking or perceived to be lacking, then there could be an allegation that's often made or inferred that it's been obtained by fraud, that there's been some sort of corruption or illicit payment that's happened behind the scenes to bring the contract the way of that particular contractor. I think there's a huge spectrum of where these sorts of claims fall on the plausibility spectrum. It could be that there are many other reasons why the contractor may have got the contract, or it may be that it's much more tenuous and you can't see any obvious reason why somebody that doesn't have any of the credentials at all, doesn't have any substance, has somehow found its way into a massive, lucrative position like that. But I think the point is that as counsel, you have to assess that very, very carefully and consider whether there are things that are just missing from your knowledge and from the documents that you've seen and the other evidence that you've seen and heard, that could actually present a perfectly plausible explanation that a tribunal will be perfectly alive to. And the reason for all of this, I think, is that, as Claire says, I think the effect of not doing this is that you present a case that could run for a year, 2 years, 3 years or more, that could be hugely toxic. These sorts of allegations can be hugely toxic as far as the tribunal is concerned, and taint and affect all of the other claims that you could be bringing that could well be good claims if the tribunal forms the impression that you just haven't given proper consideration to the seriousness of the things that you're saying, and they're based on very circumstantial pieces of evidence.
So you're saying that knowing that there is likely to be evidence out there is not good enough. You need to be able to see some of that evidence yourself before you can reach that objective view to bring in, which is obviously very difficult because of the nature of corruption evidence. It's usually concealed.
Yeah, that's exactly right. And also, you have to go a step further, going back to what we've been saying about the intent that you're typically having to prove. It's pretty rare that you're going to find yourself with an agreed set of facts, which include the mental element, if there is a mental element to the particular breach that you're talking about. It's rare that you're going to find that those issues are not evidentially in dispute. So there is going to be a limit as a party asserting these claims to how much you can really say about them. And a lot's been written about this, I think, especially in the wake of the World Duty Free in Kenya exit arbitration about a decade and a half ago. A lot's been said, I think quite rightly, about the duty of a tribunal not to set the bar so high that it just simply cannot be reached by a party that's conscientiously and properly bringing claims based on the evidence that it has. It's just a judgment call, I think, is what I'm saying, that you can't be expected to go all the way because that's virtually impossible. But you have to be very careful with the evidence that you do have, not to suggest inferences that just aren't there to be made and destroy your and your client's credibility before that tribunal.
We've spoken a lot about evidence and about clients, but what we haven't yet spoken about is the law. And at this point, Angeline, can we bring you into this discussion? Are there potentially a range of different laws that could apply to this, that could apply to alleged corrupt acts, to the alleged corrupt actors? How do these different laws intersect? How do you navigate between the ranges of different laws?
Well, thank you, Greg, for the question, and good morning, everyone. Before I start on applicable law, just picking up on the conversation about evidence, I think one of the other things that you need to bear in mind with these sorts of allegations is when you make them as a party, it may be that the evidence that you want is not in your hands and will be subject to disclosure orders against your counterparty or a third party, in fact. And so that, I think, needs to be weighed in the balance when you're deciding whether to make these claims and quite how you put them in order to preserve credibility with the tribunal at the outset. And before I dive into applicable law, because we are talking about some of the hurdles to get over when you're making out an allegation of corruption, I was really interested to see how many people in this room earlier raised their hands when they said that, to Greg's question, have you experienced an allegation of corruption? Of those people, how many have seen contracts set aside or that allegation be borne out as successful in the arbitration proceedings? I'd be interested if you'd raise your hand. Okay, there's nobody, one person, I think. So I think we can deduce from that actually that they're frequently made but very difficult to sustain, which I think is partly what we're talking about here now. In terms of applicable law, this is potentially an additional hurdle in the sense that there are various different permutations for the applicable law governing questions of corruption. And broadly speaking, obviously, your starting point, if you have a commercial dispute and it's governed by contract or perhaps a related tort dispute, the applicable law of the contract will be your starting point. A tort obviously may have different considerations depending on where the harm took place. If it's an investment treaty claim, then the likely starting point will be public international law. But I say the starting point because I think these sorts of issues tend to raise other applicable laws. And so, for example, if a license is procured by corruption, then it may be unlawful under the law of the country in which that license was issued. And so you may, in those circumstances, have an unlawful investment. Or it may be that performance, or you may have a very legitimate contract, but it may be performed illegally. And the issue there may be, say, for example, you have a consultancy contract when the only purpose is to facilitate bribes. There's nothing unlawful per se with a consultancy contract, but if what the services which are being provided thereunder are to pay bribes, well, the question might be, what is the national law of the performance of that contract, which even though your applicable law of the contract, for example, is English law, conflicts of law, may bring that law in. There may also be soft law, which is relevant. So if you have a contractual undertaking to comply with regulations, anti-corruption regulations or something similar in a country, then you may want to give some consideration as to whether that contractual obligation has been complied with, which obviously will bring in the applicable law for those regulations. And then finally, if that's not enough, there's also the question of the law of enforcement, which is not obviously always easy to predict. But the Soleimani case, one of the famous sort of English law enforcement cases, was a situation where you had a contract which for the export of Persian carpets in breach of revenue and export laws. That was illegal, but the contract was governed by Jewish law, and the fact that it was in breach of the export and revenue laws didn't affect the rights under Jewish law. So when it came to enforcement of that award, which was issued by Beth in the English courts on the face of the award could see that what the parties were seeking to enforce was contrary to English public policy, because it would effectively be enforcing an illegality. So that's also something that one has to take into account. So what do we take from that, of the various different applicable laws? I think if you are considering an allegation of corruption or illegality, then you may want to think quite creatively about what are the potential laws which may apply to that particular circumstances, because it may be that it will help you in making out your claim. That's obviously also a trap from the other side, the other perspective.
Claire, could we turn to you now? So we've had some views on evidence, we've had some views on the applicable law. Counsel's job is to pull this all together into a convincing pleading. Can you tell us about that? What are the effects of the tribunal? What are you thinking about when you're pulling together the pleadings? What are the dispute tactics that could come into play here?
Well, that's a very broad question, so I'll just pick a couple of points, and one of them Gaurav actually alluded to earlier, which is the professional obligations when you are pleading fraud or corruption. They differ from jurisdiction to jurisdiction. As English lawyers, you have sort of relatively a high bar to get over in order to properly plead fraud or fraud in particular in a set of proceedings. I think an English judge used the fact that an English lawyer should not be a hired gun. So simply because your client wants to make an allegation of fraud against the other side, you can't simply put it in your pleadings without examining what stands behind that allegation and properly assessing it. And you wouldn't want to, because you don't want to see the allegation easily batted away, because that might taint the stronger parts of your client's case. So I think sort of the takeaway point would be to only make the allegation where you are on very strong ground, because otherwise it might do more harm than good.
The ethical considerations point is quite interesting, because obviously in international arbitration we deal with co-counsel and opponents from all different jurisdictions. So there could be an inequality of arms point here, where one jurisdiction's lawyers are prevented from running a corruption claim, whereas alternatively a different jurisdiction's lawyers can do so, and you might be against an opponent that has a very different view of these issues.
That's absolutely right, and that's, I think, pretty typical of the usual melting pot of rules and ethical obligations that we all face in international arbitration, that ranges from making allegations of corruption to how you prepare your witnesses for a hearing, and that's just sort of part and parcel of our lives as international arbitration lawyers.
Angeline, putting on your arbitrator hat from here, so we've got the evidence, we've got the laws, some of the laws, it's all been pulled together into a pleading. Can you talk us through the arbitrator's perspective? The tribunal obviously will need to determine this corruption argument. How does the tribunal assess whether the corruption plea is properly made out? What's the standard of proof? What is the burden of proof? What are the issues that go through a tribunal's mind when faced with these arguments?
Well, first of all, I want to say that there are different ways in which allegations of corruption arise, and I've seen different ways in which it arises in my own practice. So it may be that an allegation is directly made, and that's something which I think we've predominantly been focusing on up until now. But perhaps later on I'll come on to say something about the situation where there are no allegations of corruption made, but the tribunal suspects, because that's quite a different situation. So just on the former scenario where a party alleges corruption, obviously you are, as a tribunal, guided by the law, the applicable law to your dispute, and then the evidential standard which applies. There is some, and so if it's English law, I mean, I think Gaurav's magnificently covered this already, but I mean, you know, you still have a balanced probability test which needs to be applied, and if a serious allegation is being made, then you have to put serious evidence forward to persuade someone that there is in fact corruption. But there is some academic writing available which suggests that because this, you know, the scenario where you've got someone on tape admitting to handing over the Adidas bag is very rare indeed. What you therefore have to do is look to various different red flags to identify whether there are the circumstances in which suggest that corruption exists. And so the sort of red flags that, just to give you a few examples of the type of things, where there's no obvious services which are being provided by the party seeking payment, where there's a corruption index of the country in which the services are being performed is particularly high, whether payment is being funneled through a complex offshore structure, and it may be, and that's just a few, you can look at, there's various different red flags that have been identified in some of the writing on this, and it may be a combination of those. I have had parties argue corruption allegations based on the red flags before me, and then there's a question, and it has been argued also that if you establish sufficient red flags, so the burden of proof shifts to the other side, and they have to then rebut the red flags. I think you have to put that analysis into an English law perspective, so the balance of probability remains the same. And red flags, I think, would raise serious concerns. And the tribunal, for example, if there's an allegation that no services are being provided, well, the tribunal would want to know what the explanation is for that. And if a party is alleging it, the burden of proof really remains on that party to allege it. But I think the tribunal would certainly want to ensure that, first of all, the allegation has been put properly to the side against which it's being made. So even if counsel who is making the allegation has not necessarily put it, it's quite a serious allegation. You want to ensure that it's the respondents had an opportunity to deal with it. And I think that if you have identified the red flags, they're the sort of things that you'd want to ensure that has been aired properly in the arbitration proceedings. But ultimately, I don't think it removes the evidential burden which is on the claimant, which they have to establish as a matter of English law, assuming the dispute is governed by English law.
And what about that situation where both parties have an understanding that there was some corruption underlying the transaction, but neither party wants to deal with it? Nobody wants to air their dirty laundry before the tribunal. Neither party argues corruption, but the tribunal suspects that something improper has gone on under the scene or behind the scenes. How does the tribunal deal with that? It's obviously a very delicate situation. How does the tribunal address that?
It is a very difficult situation. I mean, I think ultimately you have to balance fairness to the parties with ensuring that your procedure is not being abused. That's the way in which the English court deals with it, and I think that's the proper way to deal with it. The reality is that it's going to be quite a rare situation where just suspicion alone is sufficient for the arbitral tribunal to act on it. There may be circumstances that it's not as unusual as you might think it is, where a witness, when giving evidence and cross-examination, admits that something untoward has happened. And if you are in that circumstances, obviously you have something concrete to deal with, and then it's your duty as a tribunal to put it back to the parties and ask for their submissions on that particular issue. If you're in the situation where, you know, the consultancy contract where no obvious services are being provided and neither side has an explanation for that, I think as a tribunal you would want to satisfy yourself that there is an explanation for it, but you can only do it based on what the parties, you know, ultimately tell you. So that I think what ultimately leads to is a tribunal which is a bit more testing than perhaps it would otherwise be, but ultimately you're in the hands of the evidence that the parties are going to, and submissions that they give you, and that's what you have to resolve.
Now, obviously the tribunals don't have the power of compulsion like courts do. That immediately limits in some ways the investigative approach that a tribunal can make. Now, for myself, I've never had a situation where a tribunal has approached a court for assistance where neither of the parties are revealing information. I just wonder whether anyone on the tribunal, on the panel, has ever seen that quite extreme situation of a tribunal taking matters into its own hands to answer questions that the parties are refusing to answer.
I'm not sure that it can. I mean, I haven't thought about this in great detail, but I would think that I would think an application would need to be made by one of the parties to the court for assistance in those circumstances. But you know, clearly, if the tribunal is troubled, they have all the powers to ask questions to the parties before them. But I suspect that's the limit of their jurisdiction, although I'm happy to be proven wrong on that.
And that's typically my experience. It's that the tribunal then drills down a little bit to the extent that it can without, well, you know, to the extent that it can, based on the evidence that it has heard. That's typically what I've seen. I haven't seen a tribunal go to or suggest that a party should make an application to court to progress an aspect of a claim like that.
And then once the tribunal has had its deliberations and then has reached a decision and issued an award, that takes us to the third chronological section that we're talking about, which is dealing with allegations of corruption at the stage of enforcement or at the stage of challenge of an award. So here we have a situation, an award's been issued. One party believes that the award was unfair, that the award's been obtained or procured by corruption in some manner during the proceedings. The question here is, how does the arbitral process protect the allegedly innocent party in that situation? Angeline, let's take the most obvious point. What if corruption is only uncovered after the award is issued? For example, there's critical documents that are discovered to have been forged and that forgery has been concealed. For example, witnesses are discovered to have been bribed. The extreme case, even an arbitrator has been discovered to have been bribed, and unfortunately it does happen. Yeah. How can the innocent party seek justice in that situation? What are remedies are available to it?
Well, I mean, normally once an award has been issued, you have two remedies, right? The first is to challenge the award, and the second is to resist enforcement. I hesitate slightly because I think you would think that all of these types of situations, there would be a compelling argument of it would be contrary to public policy to enforce such an award. But public policy is, and there are arguments about this, but it can be an odd hybrid between it's the public policy of the jurisdiction which you're enforcing, but there are arguments to say that it's a transnational public policy. And so, for example, you might be able to rely on all of the conventions, anti-corruption conventions and so forth in terms of arguing what that public policy is. But there are instances of where after the event awards have been, enforcement of awards has been resisted on the grounds of newly discovered evidence of corruption. I think the trickier issue is where there are allegations which are made, and those allegations were raised before the tribunal, because in terms of enforcement, rather than challenge the award, then the enforcing court is grappling with the issue of respecting the decision which the tribunal has come to, which is regarded as a final decision, and not allowing its own processes, the court's processes, to be abused by the enforcement of something which is unlawful. And I think we had a case recently, not a corruption case, but a case Betamax from the Privy Council, which looked at the balancing act between finality and illegality earlier this year, I think it was. And there the Privy Council, which is the same judges of our Supreme Court, were very clear that actually if a tribunal has looked at any arguments during the course of its process and it's rejected them, then that decision is final. And it would be very rare circumstances where you could reopen that on public policy grounds. So that, I think, is quite interesting. What if, you would really have to, I think, in those circumstances, have quite compelling evidence it wasn't before the tribunal, because if the tribunal has looked at it and rejected it, then it's going to be a lot harder to resist the award on enforcement, I think.
And I think the most extreme end of the spectrum that I'm aware of, at least, situations where an entire arbitral process is a complete sham. Either the parties have colluded to obtain an award which the tribunal knows nothing about, or where a party, the tribunal and the institution are all colluding to obtain a complete sham award. And we've seen examples of that in the press recently. Claire, do you have any views on that? Does that actually happen? How to deal with that?
Yes, it does happen, and as you said, there are examples in the press, and I think this is a bit of a hot topic at the moment. Thankfully, it doesn't happen very often, but we have one example that we are dealing with at the moment on behalf of one of our own clients that is facing 2 sham arbitration awards that come from unknown institutions in the particular jurisdiction, and the awards have been rendered in circumstances where there was very little regard to due process. I can't really say much more than that about those, but there is a very high-profile example that is covered in the press at the moment, which is the case by a number of Saudi and Egyptian claimants against Chevron and Saudi Aramco, based on rent and oil exploration revenue from land leased back in, I think it was 1949. And the administering institution in that case was called the International Arbitration Centre, the IAC, adding a little bit more to the arbitration alphabet soup, and one that we're not familiar with. So it's an institution that really was unknown to the arbitration community. And the 3 arbitrators, I think, went through a number of changes, but eventually 3 arbitrators did issue an award, and it was an award for $18 billion against Chevron and Saudi Aramco, and the follow-up machinations to this are still ongoing, and you can follow them in the press if you're interested. The 3 arbitrators have been convicted of fraud and forgery offences by the Egyptian courts. I think 2 of the individuals who were involved in this IAC institution have also received convictions in Egypt. But the claimants are now taking this $18 billion award around the world to various courts and trying to enforce it. And they are facing the public policy exception hurdle that was referred to earlier. They have thus far been unsuccessful, and the various US courts have been, I think, quite dismissive of these attempts to enforce, but they will no doubt keep on trying because the prize is obviously extremely high. So whilst these sham arbitrations are rare, they can happen, and then once the awards are rendered, the options, as Angeline outlined, are either trying to challenge the award at the seat or to challenge the enforcement in whatever national court is being applied to.
Now, I'm conscious that we're about to eat into the coffee break. So before we do so, Tom, could I turn to you and see whether there's any questions that have come up?
Yep, thank you, Greg, and thank you again to everyone who's been asking questions. There have been a few that have come in, which is great to see. Let's start with this one. Is there a risk in arbitration compared to going to court of cautious tribunals not being willing to consider a set of red flags to reach a finding of corruption?
I guess this one's for me. Well, no, I don't think so. I think that means you have to the extent you can, select your tribunal carefully, in that you want to, I mean, this is a serious question. Obviously, when the prime consideration when you're thinking about, at least to my mind, when you're thinking about who you want to select as your arbitrator, is that you want to if you're making a corruption allegation, you want to identify someone who you believe will be robust and deal with it robustly. But, you know, I don't think that the sort of standard or integrity is any less through arbitration proceedings than it is in court proceedings. At least that's what I would like to think anyway. I've not sat on a tribunal where I felt that's an issue.
I mean, I would say the same thing. I think that you have to be quite disciplined. Your tribunal has to be quite disciplined about exactly what the scope of their powers are in light of the allegation that's being made. And you have to be careful. The tribunal has to be careful that it's not going into areas of investigation that are properly for the criminal authorities in the jurisdiction that could be implicated. You know, we talked about the governing laws earlier, but also the various authorities that could be interested, especially in an energy context, for example. You might find that there are regulators that are interested in whether or not licenses were obtained by fraud or dishonesty or corruption. So I think to that extent, I don't see any reason why, and I've never experienced any reason why a tribunal would steer clear, if you like, of the allegations. But you do have to be careful about exactly what the ambit of the remedies that are available that you can order are, and where the challenges will be with that.
Thank you.
I mean, I would say, sorry, just on that, it's slightly connected, but I think obviously, and I think the next panel's talking about this a bit, the limits of confidentiality of arbitration. But one thing we haven't really touched on is the interplay between regulatory proceedings, for example. Gaurav just mentioned it a bit now, and arbitration proceedings. So, you know, I have seen an example of where a corporate has brought an arbitration claim because they are subject to investigation. And what they want to achieve through the arbitration proceedings is to ensure that when they're paying out on a contract, there's some insurance there that somebody has looked into whether this contract is legitimate or not effectively. And you may want to do that in confidential arbitration proceedings rather than necessarily in court proceedings. But that is that's a scenario we haven't touched on.
And we've just got time for one very, very quick answer because we didn't eat into the break too much. Do the SFO have the appetite to take on sham arbitration cases if they have jurisdiction, or would a private prosecution be needed?
I think we're very nervous about that question. I mean, I'm not an expert lawyer on SFO matters, so I couldn't really advise you on what they would do. But I don't see why not as a matter of principle. If basically the arbitration process is being used to effectively clean money or something along those lines, then I don't see why it would be different to anything else.
I think there is an issue of jurisdiction there as well. So I'm not an SFO expert by any means, but as I understand it, they'd be investigating fraud within the UK and within a UK jurisdiction. What I understand of those sham arbitrations is that they're in perhaps less rigorous jurisdictions, and then the award is a self-standing award which is brought to an English court. And in that situation, the fraud hasn't been perpetrated in an English court, rather the fraud has been perpetrated in the other jurisdiction. And I don't think the SFO would have jurisdiction there. I might be wrong, but I don't think so.
Brilliant. Well, I think we've literally just run out of time, and that gives us just over 10 minutes for a little coffee break. But please join me in thanking Greg and the rest of the panellists for a brilliant session again.